All right, good morning. Welcome to the 294th District Court. My name's Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Joey Greer. Jeffrey Lumen. Aaron Vasquez. Kiana Walker. Ms. Walker will be appearing via Zoom this morning. Chase Harrison. Bradley Bearden. Cherry Roach. Thank you, Mr. Waller. Clinton Tinsley. Thank you, Mr. McBride. Gage Bullard. All right, Mr. Bullard, you can meet with pretrial release, sign your notice of appearance. The court has granted Mr. Platton's motion for continuance, and I've reset you to May 12th, but we'll have that on your notice of setting. Just a moment, Ms. Tabraham will bring that to you. Then you meet with Mr. West, and then you'll be free to go. Ryan Norris. Christopher Blevins. James Buchanan. Ashley Earlston. Susanna Frisbee. Joshua Gomillion. James Goodson. James Goodson. All right, thank you, sir. Zibasek Good, and he is on Zoom. Mr. Schmidt, I see him in the waiting room, so we'll recall him. Joseph Tudor. Here. Christopher Watson. Christopher Storm Watson. Cletus Pippin. Jimmy Pickens. Cheyenne Williams. Is there anyone whose name's not been called and you expect to be on the docket? Mr. Lawhorn, you ready? Cherry Roach, cause number CR-25-213. Mr. Lawhorn, we're set for docket call.
Yes, Your Honor. The announcement is we have reached an agreement, 98% of an agreement that we'd like to have this set for a plea on May 12th at 9 a.m. We believe that we can, the only last issue is a minor issue. We'll work it out for them.
Okay. All right, courts, going to set Ms. Roach then for plea before the court May 12th. If she doesn't enter her plea, that will be also a final docket call. That'll be at 9 a.m. Once she signs, ready to go. Hope you feel better.
Thank you. I appreciate it.
You're welcome. Cletus Pippin. Cause number CR-25-11, and Mr. Pippin is set for final docket call today. Mr. Wells, go ahead.
Yes, Judge, and I will have to do a why, and here's why. Early on, there was kind of a bottom line that would be a plea deal that, was not what I wanted, but would work. And then over the process of this, we got sidetracked with the restitution issue. For the last few settings, we've resolved restitution, but now there is one kink in the plea deal. I think we can resolve it if you could give us, so say maybe June 15th, and I think it'll be at a point then that we can get a plea done and not set it for trial.
Yes, Your Honor. I think we have everything substantive. It's a relatively ancillary issue that we have to try and figure out and work out and see if we can get it agreed on.
How about we just set it for plea on June 15th?
Sold.
Just set it for plea, and if he rejects the plea that day, then he'll be set for trial.
That's fair enough,
There'll
Judge.
be no more negotiating.
Fair enough.
Fair enough. All right, so June 16th at 9 a.m.
Let me look right quick. June 16th.
I've also got I got a couple other dates in June. I've got June 2nd, 4th, or 16th.
June
2, 4, or 16th.
June 16th, 9 a.m.
Yes, sir.
That works.
All right, court sets Mr. Pippin then for plea on June 16th at 9 a.m. Once he signs his appearance, he's free to go.
Thank you, Judge.
You're welcome. So, Rod, you ready?
Yes, sir. I've got Clinton Tinsley this morning on the docket.
Mr. Tinsley, this is cause number CR 25-238, State versus Clinton Ray Tinsley for final docket call.
Judge, if we may, first of all, I want to acknowledge that we appreciate the court's patience on this deal already. However, I've spoken with the district attorney. We've got an offer. The offer is not bad, but the client had their potential collateral consequences vis-a-vis his child and other things that don't have to do with this court. But what we're asking for is another reset and leave the offer open until the reset. I've spoken with the state. They're not opposed to this. And also assure me that even if it went on the trial schedule, it wouldn't be first up. It's not like we're messing up with the court's trial calendar if we push it.
Well, the problem is I've given him a deadline to make a decision today to either accept the plea agreement or go on the trial docket. Those on the trial docket, we're not pleading. So
Understand.
he's basically asking me to just violate my own policy and just reset it again to give him more time. And I think that the last time we talked about this case, you're not the first attorney on this case. So he's had a longer time than most other people. So probably the majority of people, he's had much longer. So today's the day. If there's an offer, either accepts it or rejects it. Either one, and if he rejects it, then we set it for trial.
Very
So
good.
he's got to make that decision.
Okay. If we can go out in the hall,
Sure.
just push us to the end of the docket.
Yes,
perhaps.
I'll recall you.
Thank you, Judge.
Any other councils ready? Okay. Torkins, how are
Yes.
you?
Good, Your Honor. May we approach?
Yes. Mr. Harrison, come on up. CR 25-131. All right, court is going to set Mr. Harrison for initial docket call on June 2nd. Court will plead its in-camera review and redaction of any records that are going to be released, subject to the subpoena. And the DA's office is going to continue working with the children advocate. So June 2nd at 9 a.m. and Mr. Harrison's free to go.
Thank you, Judge.
Joey Greer. All right, this is cause number CR 26-11, State versus Joey Wayne Greer. Mr. Greer, you've been indicted by the grand jury for a second-degree offense of possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams. And that does carry a range of punishment if you were to be convicted and sentenced to not less than 2 years in prison or more than 20 years in prison, and a possible fine not to exceed $10,000. Do you intend to hire an attorney to represent you in this matter? If I reset you for about 30 days, do you believe that would give you enough time to hire an attorney? All right, so Mr. Greer, going to reset you. It's going to be a couple days shy, but I'm going to set you on May 20. Actually, I'll set you June 2nd, June 7th. That'll be for arraignment, and you'll need to bring your attorney on that date, okay? Thank you. Ready to go. Mr. Greer, have you met with Mr. West yet, the pretrial release officer? You have? Okay, then you're free to go. Ms. Frisbee, where's Ms. Frisbee? I'm gonna have you meet with the pretrial release officer before I call your case. So you come on over here. Mr. Head, are you ready or do you need time?
All right, I believe we're ready. I've signed everything on email. If that's it.
Yeah, let me check. Let me see if it showed up. It's a plea, right? Yes.
And Your Honor, it may still be with probation because it is a probation plea.
Okay. We'll check on that, Mr. Head.
Yes, sir.
I don't see it in my email just yet. So they may be working on it in the back. Ms. Walker, Deanna Walker.
Your Honor indicated that was.
Oh, I'm sorry. Yeah, that's via Zoom. Thank you, Mr. Hernandez. Don't have her in Zoom. Please sit down. You ready? Yes. Mr. West wanted me to let you sit down for like 20 seconds and then call you back up, but I told him I'm right. Who would you like to call first?
Let's call Jeffrey Don Lumen.
Mr. Lumen? This is cause number CR 26-23, State versus Jeffrey Don Lumen. Mr. Lumen is set for arraignment today. Mr. Lumen has requested, are you retained on this one, Mr.
No,
Schmidt?
sir.
All right, court has appointed the Honorable Richard Schmidt as counsel. You ready for arraignment?
We are, Judge. I was provided a copy of the indictment. I went over that briefly with Mr. Lumen. His name is spelled correctly. We'll waive reading and a plea of not guilty. Ask for a pretrial sentence.
All right, the court will enter Mr. Lumen's plea of not guilty into the record. Court will find that he has waived the formal requirements of arraignment, and we set Mr. Lumen then for pretrial hearing on June 2nd at 9 a.m.
James Buchanan.
Mr. Buchanan? This cause number CR 25-196. Mr. Buchanan set for docket call.
Judge, we're gonna ask for a final doc call setting. See if we can't get it worked out.
Any objections?
No objection, Your Honor. Thank you.
All right, court sets Mr. Buchanan for final docket call June 2nd at 9 a.m. Once he signs his appearance.
Ashley Earlston.
Mr. Olston. This cause number CR 25-245, State versus Ashley Ann Earlston. I believe today is our final docket call setting.
That's true, Judge. I met with the state last week on Ms. Earlston's case and provided some new information. We're gonna ask for an additional final docket call. Ms. Earlston.
Your Honor, there is some things that Mr. Schmidt provided to me that I can follow up on. Could ultimately end up being dispositive to the case.
I'm in a hard situation here because I've told Mr. McBride's client that today was the day. So I feel like I would not be fair to do that for Ms. Earlston. How long will it take you to review the information? Does it require you to do office work on the phone, or is it something that y'all can talk about today and have wrapped up before include our morning docket?
It
We
would,
have to wrap it up, Judge, not today. So I understand the court's position. I mean, the alternative would be to set it for trial.
and Your Honor, it would require sending an officer out to do an interview and conduct a little bit further investigation.
Since she hasn't reached a plea, let's set it for trial. And then if the parties feel like this information intervening to court's policy, then you can let me know. Consider setting it, considering.
Yes, sir. Thank you. What was that date?
All right, so she'll begin the jury docket process, jury selection process on next Monday, May 4th. So Ms. Earlston, when you report on May 4th, you will not come to the courtroom. You'll meet with my staff downstairs. The pretrial release officer will be down there. And Mr. Schmidt will not be required to be here, as your case will not be reached for trial that day. And he will not be required to be here until the case gets in the top 10. So stay in contact with him and your boss. Okay? So this is
Joshua Gamillion.
this is cause number CR 25-249, State versus David Goldmillion. Same situation, final law.
It has to set Mr. Gamillion for a plea on that June
So it'd be morning or afternoon?
Morning, please.
All right, court sets Mr. Goldmillion plea before the court on June 2nd. What type of plea is he?
It's a plea for probation, yes, sir. James Goodson.
James Robert Goodson, CR 25-250. All right, Mr. Goodson set for final docket call.
That's correct, Judge. One second. Judge, the state has made an offer. Mr. Goodson has chosen to reject that offer. We denounce ready for trial.
All right, and what offer has been extended and rejected?
18 months state jail or 10 years TDC.
All right, court finds that the state's made an offer, the defense has rejected it, and the court is setting Mr. Goodson in for jury selection beginning Monday, May 4th. At 8:30. And so, Mr. Goodson, you'll report downstairs when you come in. You will not come in here. We'll be picking a jury for another case. My staff will be down there and they'll give you more information. All right.
Downstairs. Gotcha.
Next.
Christopher Watson.
It's cause number CR 22-198, State versus Christopher Storm Watson. This is on the state's motion to adjudicate.
That's correct, Judge. We have reached a tentative agreement with the state. It's going to require we work out a couple of details, but we'd ask to set him for plea on the June 2nd. Though.
All right, court sets Mr. Watson for plea June 2nd. Is that morning or afternoon?
Morning, sir.
Court sets Mr. Watson at 9 a.m.
Joseph Tudor.
Joseph Scott Tudor, CR 25-284. Tudor set for docket call.
That's correct, Judge. As I announced in our previous setting, we do have an agreement on Mr. Tudor's case that requires him to participate in some classes. In exchange for successfully completing that, the state is going to dismiss the case against him. The concern that I had obviously was the financial expense of those classes. I think I've gotten some information from probation department on that. It's going to be hard for him, but I think he can manage. So we're going to start those classes. So we're going to ask for a 60-day reset on the, status for those. That's open.
State's unopposed to setting it on status, Your Honor.
All right, court will set Mr. Tudor then for Tuesday, July 7th. For status, is this some kind of batterers intervention program?
Yes, sir.
So, Mr. Tudor, you're still going to be required to contact and report to the pretrial release officer. Just because you're not coming back to court to July doesn't mean that you don't do whatever you thought to do as far as drug testing or whatever else. Okay. So make sure you stay in contact with him.
Absolutely.
All right, ready to go. Let's go.
We've got the last one ready is, Mr. Zabisek Goot.
All right, I'm gonna have you bring your microphone forward here so that. All right, Mr. Goot, can you see and hear me okay?
Yes, I can, Your Honor.
All right. Good to the right this one. All right, this is cause number CR 26-12, State versus Zabisek Goot, and we're set for pretrial. For the record, Mr. Goot is appearing via Zoom with court's permission. Go ahead, Mr. Schmidt.
Judge, at this time, we do not have any pretrial motions that need a hearing. To ask for a docket call set.
All right, court finding that there are no pretrial issues, court sets Mr. Goot then for docket call setting on Tuesday, June 2nd at 9 a.m. And Mr. Goot, you'll need to be in court on that day. Okay?
I have to come in court in person?
Yes, you do. June
Yes,
2nd.
Your Honor.
June 2nd.
June 2nd.
Yeah, stay in contact with your attorney and your bondsman.
Yes, Your Honor.
All right. You're free to go.
Thank you. You have a wonderful day, Your Honor.
You as well.
Thank you.
You said that was the last one you had ready at this time? Yes. Mr. Head, I have Mr. Bearden ready if you're ready. Yes, sir. This cause number CR 25-195, State of Texas versus Bradley J. Bearden. Mr. Bearden, sir, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, sir. Lower your hand. All right, your name is Bradley J. Bearden, is that correct? Yes. And Mr. Bearden, are you a United States citizen who reads, writes, and speaks English? Yes. Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mike Head. Are you pleased with Mr. Head and the work that he's done as your attorney? Yes, very pleased. Do you have any questions about any of the paperwork that you have read and signed?
No, sir, not at all.
You understand everything?
Yes, sir.
Mr. Head, do you believe Mr. Bearden to be competent to enter into this agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been informed of his legal rights?
I do, Your Honor.
All right, Mr. Bearden, I see that you are charged by indictment with a third-degree felony offense of unlawful possession of a firearm by a felon. That does carry a range of punishment of not less than 2 years in prison and up to a maximum 10 years in prison and a possible fine not to exceed $10,000. I see that there is a plea agreement in this case. The recommendation is upon you pleading guilty that the court consider the evidence, assess punishment at 5 years confinement in the Texas Department of Criminal Justice with a recommendation that that sentence be suspended and you be placed on community supervision for 3 years. In addition, the other terms of the plea are that you would pay a $1,000 fine, court costs of $290, reimbursement fees of $35, and that there would be a weapon forfeiture associated with the prosecution in this case. Mr. Bearden, is that your understanding of the plea agreement?
Yes, sir, it is.
Understanding those things, I would ask you at this time, how do you plead to unlawful possession of firearm by felon?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty here today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Head, any objection to the stipulated evidence?
No objection.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
Nothing further, Your Honor. Thank you.
from the defense?
No, sir.
All right, court is going to consider the evidence. All right, the court, having considered the evidence, finds that there is sufficient evidence to convict the defendant of the offense. Court will follow the plea agreement and recommendation. The court hereby convicts the defendant, Bradley J. Bearden, of unlawful possession of firearm by felon, a third-degree felony, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice. The court suspends the sentence, places the defendant on 3 years community supervision. The court orders the defendant to pay a $1,000 fine for a cost of $290 in reimbursement fees of $35. Furthermore, the court does forfeit the weapon that was seized in the prosecution of this matter. Mr. Bearden, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come over here to be fingerprinted, Sergeant Martinez. After that, you will meet with the probation officers.
Thank you, Your Honor. May I be excused?
Yes, thank you, Mr. Head. Good to see you.
Yes.
Mr. Sanders, you and your client ready?
Yes, we approach, I approach.
You may.
Absolutely.
Right, this is cause number CR 25-270 and CR 25-271, State of Texas versus Ryan Dwayne Norris. Based on the party's request, the court will set Mr. Norris to enter a plea on August 25th at 9 a.m. And once he signs his notice of appearance, he's free to go. Thank you, Judge. Mr. Norris, just make sure that while you're awaiting the next appearance in court, that you stay in contact with Mr. West, your pretrial release officer. Okay?
Can I get this information?
Yes, you can. He'll meet with you out in the hallway whenever
Okay.
he does with Mr. Sanders.
Okay, Joe.
He's free to go. He's going to meet with Mr. West outside just to get us in contact information. All right, thank you, Judge. Mr. White, are you ready? Sir. Who would you like first?
Can we call Miss Williams?
Cheyenne Williams, CR 26-24. All right, Ms. Williams is set for arraignment today.
If the police court, Miss Williams will waive formal reading of the indictment. She's the person named, her name spelled correctly. She's aware of what she's been charged with, and at this time will enter a plea of not guilty.
All right, the court will enter Ms. Williams' plea of not guilty into the record, finds that she's waived the formal requirements of arraignment. And the court will set Ms. Williams for pretrial. Mr. White, are you available on May 26th?
Yes, sir.
All right, we'll set, does that give you enough time? That's a little less than 30 days.
The only concern I would have on this, Judge, is, I talked to Mr. Hernandez. I believe that there's gonna be, because it involves a child, there's probably gonna be a CAC, and I believe there's a CPS investigation.
You want to move it to June? We can do, I'll give you a couple days. We can do June 2nd, 4th, or 16th.
Check, 1st of June. We do the 16th, Judge.
Any objections from the state?
No, Your Honor, thank you.
All right, court sets Ms. Williams in for pretrial June 16th at 9 a.m. Ms. Williams, have you met with the pretrial release officer, Mr. West? Okay, you need to do that before you leave, because there's conditions of pretrial release that you have to comply with.
Yes, sir.
So you want to have this in the hallway. Burns, can you have Mr. West speak on Ms. Williams? You're ready, Mr. Schmidt.
Susanna Frisbee, Judge.
Ms. Frisbee, if you'll come forward. This is cause number CR 25-230, State versus Susanna Aurora Frisbee. I believe we're set for a plea today. Is that correct?
We are, Judge. We're gonna ask to reset Ms. Frisbee's plea to June 2nd. There is a companion CPS case ongoing, and we need to check in on some compliance issues with some of the CPS case work. Come back on this June 2nd, hopefully get it resolved.
Any objections from the state?
State's in agreement, Your Honor.
All right, the court will note for the record that Ms. Frisbee has been drug tested by the court and she is negative. The court will grant the reset to June 2nd. Plea. Be at 9 a.m. Right, are you ready? Mr. Pickens, I have this plea if you're ready.
Yes, sir.
Mr. Pickens, come on up. This is cause number CR 25-102, State versus Jimmy Don Pickens. Mr. Pickens, if you'll raise your hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, sir. You can lower your hand. All right, your name is Jimmy Don Pickens Jr., is that correct?
Yes, sir.
And Mr. Pickens, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work that he's done for you?
Yes, sir.
Do you have any questions about any of the paperwork that you've read and signed today?
No, sir.
Mr. White, do you believe Mr. Pickens to be competent to enter into this plea agreement? And if so, that he's doing it intentionally, knowingly, voluntarily, after having been informed of his legal rights?
I do, Your Honor.
All right, Mr. Pickens, I see that you are charged by indictment with a third-degree felony offense of unlawful possession of a firearm by a felon. That does carry a range of punishment of not less than 2 years or more than 10 years in prison and a fine of not more than $10,000. I see the plea agreement and recommendation is upon you pleading guilty. State's recommending that the court assess your punishment at 10 years in prison, but they're also recommending that the prison sentence be probated or you be placed on community supervision for 5 years. In addition, you would be ordered to pay a $3,000 fine plus court costs and reimbursement fees. And as part of the plea agreement, state is resolving an unfiled possession of a controlled substance case against you. Is that your understanding of the plea agreement? All right, understanding those things, Mr. Pickens, how do you plead to unlawful possession of firearm by felon?
Guilty, sir.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt. Mr. White, any objection to the evidence being admitted?
No, sir.
Simply the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
No, Your Honor, thank you.
Anything further from defense?
No, sir.
All right, the court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. Court hereby convicts the defendant, Jimmy Don Pickens Jr., of unlawful possession of firearm by felon. Court assesses punishment at 10 years confinement in the Texas Department of Criminal Justice. Court suspends the sentence, places the defendant on 5 years community supervision, orders the defendant to pay a $3,000 fine, $290 court costs, and $35 in reimbursement fees. Court also takes into consideration unfiled case DA 2024-1037, possession of controlled substance. All right, Mr. Pickens, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'll have you come forward to be fingerprinted with Sergeant Martinez. Your Honor, that's all. Thank you, Mr. White. Maybe this afternoon. You may see if I can drum something up for you. There might be some people in the jail. Go to where? Go to call. It's my voice. You're working through it. I know you know. All right, this is a sanctions court hearing for Mr. Aaron Vasquez. This is cause number CR 21-394. All right, Mr. Vasquez, your last sanctions court, I ordered you to do 20 hours of community service and you've completed that. Where did you do your work at?
Maintenance.
And then I also ordered you to pay $100 towards your fees and you completed that. I think the only issue that we have left is that you have a girlfriend, correct?
Yes, sir.
And it looks like one of the requirements is that she needs to take a chaperone class prior to you being able to have contact with your child.
Yes, sir.
And so you understand what the chaperone class is? You
Yes.
understand the purpose of it. So she needs to get that done in order for you to be able to have that contact with your child. And I'm sure that you want that contact with your child, right?
Definitely.
So there needs to be a priority. Either she gets it done or you don't see the kid, or you get rid of her and you see the kid. Make sense?
Sir.
I wouldn't let someone else stand in the way of seeing my child. So if you can't get this taken care of, then you're just not gonna be able to see your kiddo because it is a matter of protection based on what you're charged with, okay?
Sir, I think Mr. Molly had a class, was it 2 weeks ago, I think, but it was already last minute still. He doesn't have it until August, and Miss Clark said that she was trying to see if I can find another person I can do the class with for her.
Okay. Yeah, keep on working with Ms. Clark, and if she's looking, I know she's looking hard, so you can try to help her as well. Anything that you find, don't do it.
Right.
Let her know about it and see if she approves it.
Right.
Okay, because August will be a long time.
Yes, sir.
So I couldn't see one of my kids until August, I
Well-
would not be a happy camper.
Yes, sir. I want to be there whenever he turns 1, so that's why.
Okay, good. All right, so you know what you got to do and you're on top of it. So I'm gonna have you come back. Have you come back June 2nd, okay? We're gonna do the same thing, $100 towards your fees and 20 hours of community service, okay?
Yes, sir.
On those fees. Probation, is that or probation, so you'll just pay $100 towards your probation fees, okay?
Yes, sir.
All right, Mrs. Abraham's got a form for you to sign. It's got your reset date. All right, ready to go.
Thanks. Have a good
You're
one.
welcome. See if Ms. Walker appears at 10 for sanctions court, and then I think Mr. McBride, I guess, is still discussing with Mr. Tinsley. Okay. And then we've got Mr. Blevins, is that right? Mr. Schmidt,
Yes.
we haven't done that, okay. And those are the three, so one sanctions court, two please. All right, court's gonna stand in recess, and once Mr. Schmidt or Mr. McBride's ready, we see Ms. Walker come online, then court will resume.
Yes, sir.
All right, court calls cause number CR 25-154, State of Texas versus Christopher Wayne Blevins.
Yes, sir.
All right, Mr. Blevins, I see that you want to enter into a plea agreement to resolve your case today. I'm going to have you raise your hand so I can place you under oath. Do you swear that the testimony you give to the court today, the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Your name is Christopher Wayne Blevins, is that correct?
Yes, sir.
Mr. Blevins, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes, sir.
Do you have any questions about anything that you've read over and signed today?
No, sir.
Mr. Schmidt, do you believe Mr. Blevins to be competent to enter into this plea agreement? And if so, that he's doing it intentionally, knowingly, voluntarily, after understanding his legal rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Blevins, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. If you were to be convicted and sentenced, that would carry a range of punishment of not less than 6 months or more than 2 years, confinement in a state jail prison, and a possible fine not to exceed $10,000. The plea agreement and recommendation in this case is upon you pleading guilty. The state's recommending that the court defer a finding of guilt to a lesser included offense of the possession of controlled substance. Penalty group 1's less than 1 gram. Your punishment, your community supervision would be a period of 3 years. You would have a $1,500 fine, restitution of $180, and the state's agreeing to reject 2 unfiled cases, one being an evading arrest or detention, and the other being a tampering or fabricating with physical evidence. Mr. Blevins, is that your understanding of the plea agreement, which you're asking the court to approve?
Yes, sir.
Mr. Blevins, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone forced you, threatened you, or pressured you to plead guilty today?
No, sir.
The court will accept the defendant's plea of guilt. Any objection, Mr. Schmidt, to the introduction of the stipulation of evidence?
Object.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
The defense?
No, sir.
All right, court will review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Do have some questions and concerns about whether or not Mr. Blevins is going to be able to meet the strenuous conditions of community supervision, such as transporting himself to and from the community supervision office for reporting and drug testing, community service, so on. Mr. Schmidt, anything? Says he was riding a bike. He got arrested for trace amounts of methamphetamine. Is he gonna be able to come to Canton to meet with the probation officer?
I think that the bicycle issue is temporary. Yes, transportation. Okay.
So, Mr. Blevins, if I approve this agreement, you're gonna be, do you have a job? You working?
Not at the moment, sir. I'm taking care of my mother. She's on hospice. So, I mean, I do side jobs here and there.
You understand you're gonna have reporting fees, you're gonna have you're gonna be drug tested, you're gonna have drug fees, you're gonna have to go do community service. That's gonna take gas. That's gonna take time and effort. Are you gonna be able to do all of this?
Yes, sir.
All right, the court will approve the plea agreement. The court hereby finds that there is enough evidence to convict the defendant of the offense. The court will defer a finding of guilt, places the defendant on 3 years community supervision, orders that he pay a $1,500 fine, restitution of $180. And the court hereby resolves under section 1245, the unfiled cases DA 2025-516 and DA 2025-515. Mr. Blevins, your order to pay court costs of $290 and reimbursement fees of $535. It's a lot of money. Understand that?
Yes, sir.
You're gonna have to get a job. I understand you're taking care of your mom. I'm sorry she's on hospice, but you're not gonna be able to put all that on the back burner.
I get it done.
Get it done. All right, I'm gonna take you at your word. All right, Mr. Blevins, you hereby remanded to the custody of the probation department. Have you come forward to be fingerprinted with Sergeant Martinez? Walker? Oh, actually, that's not you anymore. She's sanctions court.
Wanna get sick? You wanna get sick? No.
Hello?
Hello, Ms. Walker. All right,
Hello, good morning.
can you see and hear me okay?
Yes, sir.
All right, so we're gonna just have a quick hearing on your sanctions court. It looks like I ordered you last time you were in court to pay 200 for probation, 100 court collections, and 20 hours of community service. You complied on all three of those. And where did you do your 20 hours of community service?
At the MLK Center, Martin Luther King, Dallas County.
Good. So what I'm gonna do is I'm gonna reset you to June 2nd, and I'm gonna do the same thing, the same three things. 200 to probation fees, 100 to court collections, 20 hours community service. And I'll let you appear via Zoom on that day as well. Okay?
Yes, sir. Thank you.
That'll be June 2nd, and we'll do 10 a.m., okay?
Yeah.
All right, do you have any questions? Still there?
Sir, I'll take
Okay.
care of.
I'm sorry,
I appreciate it. Thank you so much.
well, you're welcome. There's a little bit of a breakup
I
there.
said I appreciate it. Thank you so much.
Okay.
Oh, I'm
You're-
sorry.
You're welcome. It's okay. Yeah, the connection's not riveted. You're welcome. So report back in Zoom, 10 o'clock on June 2nd. You're free to go.
Thank you. Have a good day.
You're welcome. You can just hang up. That's okay. You're right. So. Wouldn't say that's true.
That's called.
I can hear that. Yeah, Dave. Right, I saw you.
Apparently you walk outside, your honor. Okay. You walk outside, you make a phone call.
Okay, great. Thank you. All right, court will stand in recess, wait for Mr. McBride and Mr. Tizet. Mr. Tinsley, come on up. Court's on record, cause number CR 25-238, State versus Clinton Ray Tinsley. Any update? Mr. McBride?
Yes, Judge, I think we're gonna put it on the on the trial docket. I apologize. He does not want to plea. We've considered all the options and evidence. We've gone through everything, multiple times, and he'd like to trial.
Very well. And what offer was extended by the state that's been rejected by the defense?
Fine deferred, no bid, anger management.
Yeah.
Dropping a terroristic threat, 1245 terroristic threat case.
$2,000 fine, Your Honor. It was BIP instead of the, anger management instead of the BIP, yes.
All right, Mr. McBride, your client understands that, once he leaves today and we set it for trial, then that's what we're gonna do. We're gonna put a trial and, I'm not gonna allow him to accept this offer, after today.
Understood. Understand that?
Yes.
All right, then the court will place Mr. Tinsley on the jury trial docket beginning Monday, May 4th. So Mr. Tinsley, you will report downstairs. My staff will be there. You won't come into the courtroom. We'll be actually picking a trial that day for another case. So you'll meet with them down there. Mr. West will be down there, the pretrial release officer, or somebody from the pretrial release department. And they'll give you a reset date and notice. You'll sign that. And then Mr. McBride's not going to be required to be here because it's not an official court appearance. And once your case gets close to being in the top 10 for trial, then we'll notify Mr. McBride. Okay? So stay.
You said Monday, the
Monday.
4th.
Yes, and so you'll come in Monday, you'll sign your reset notice, and you'll do that every month until your case is reached for trial.
On the 4th of every month?
No, not the 4th. Just next week, it'll start on the 4th. It might be a different Monday the next month because my trial weeks change.
Is there a time, sir?
Yes, 8:30.
Uh,
8:30. So do you have your notice of appearance slip filled out? We'll need to have that filled out. You'll need to sign that May 4th at 8:30. And so stay in contact with your bondsman and pretrial release officer and your attorney. Okay?
Judge, you said 8:30 in the morning.
8:30, yes. And you'll come in there. There'll be a lot of people coming in for jury selection, but it's Ms. Abraham, my staff will be down there. They'll talk to you. They'll notice, reset notice like that. You'll have a new day. You'll meet with the pretrial release officer, do anything he needs you to do, and we'll get you out of there. Okay?
Sure.
Thank you. And appreciation for patience
Yes, sir.
on the board and board staff hanging around and for the state for working with me to get this far. Make sure
Yes, sir.
everybody appreciate the diligence and the effort.
Yep, you're welcome on behalf of the court. I'm sure the state is appreciate you for saying that.
Thank you, Judge. We'll see you.
All right, I believe that completes the court's morning docket. Court will stand in recess and resume at 1:30.